So I think probably the starting place for us is what the law was prior to the Students for Fair Admissions case. So for decades, there was this well-established doctrine, and essentially the idea is affirmative action, because at least in public universities, and we'll get back to that, is technically race-conscious behavior under the way that the Supreme Court has designed that doctrine. And a lot of people, myself included, think this is a mistake. Affirmative action is treated as a form of race discrimination. And so, as a form of alleged race discrimination, it gets strict scrutiny, right? So, it gets the most demanding form of review by a court in which the government, and again, we'll talk about the fact that Harvard is not the government in a few minutes, but the government is obligated to show that it has a compelling interest and that the thing that it does, in this case, race-conscious admissions, is narrowly tailored to achieve that compelling interest. And so the first question that we have to ask about the Students for Fair Admissions case is how much of the previous legal framework still exists, right? So the prior law was diversity in higher education is a compelling interest. And so universities got to engage in affirmative action in order to achieve the educational benefits of diversity. And the Supreme Court doesn't actually say, well, that's not the law anymore. The Supreme Court never explicitly says we're overruling Greta versus Bollinger and holding that diversity isn't a compelling interest. Rather, what the court does is it focuses, in my mind, on the mechanics of strict scrutiny. So, as I understand the core notion of the court's holding, even if diversity in higher education is a compelling interest, of course, strict scrutiny indicates that you still need to show that the use of race is narrowly tailored in order to achieve that. And that has like two different implications, right? So this notion of narrow tailoring requires, number one, that there isn't any more consideration of race than necessary in order to achieve diversity in higher education. So it's kind of like, well, there has to be a stopping point. And then second, and I think this is really a logical implication of the first idea, that a school has to be able to prove that what they're doing in terms of race-conscious admissions actually achieves diversity in higher education. Because if it doesn't achieve it, then it can't be necessary to do it, right? Like if I say, it's necessary for me to pet my cat in order to like keep the rain from coming. And like I pet my cat and the rain still comes. Well, I can't really say that I only pet my cat as much as necessary to keep the rain from coming. That's a terrible, ridiculous example. But, it captures the idea that, like, logically speaking, at least under Supreme Court logic, to say that something is narrowly tailored to achieve some other end implies a certain degree of efficaciousness. And the burden of proof is on the school in this case. That's another implication of the strict scrutiny doctrine. And so really again, my reading of the case is that really the entire case is about the difficulty that Harvard and UNC have in proving that their use of race was narrowly tailored because they couldn't prove, in the court's opinion, that there was a relationship between race-conscious admissions and diversity. And why is that? Right, because certainly you might think, okay, right, like they engage in race-conscious admissions, they have a classroom that itself is more diverse, there are more people from different backgrounds in the room. That seems like it should be pretty easy to prove, right? But actually, what the court's going for, because the thing that was the compelling interest was really the educational benefits of diversity, what the court was really asking Harvard and UNC to do was to show, okay, like there's some kind of way that they can measure. Okay, we've like gotten the educational benefits of diversity, and so now we can stop doing race conscious admissions. And it's this need for like measurement that's really the problem. And so the court criticizes the universities over and over again for having this kind of amorphous, vague theory about what kinds of things indicate whether or not the educational benefits of diversity are achieved. And so, because the court thought that Harvard and UNC couldn't prove that, even if diversity is a compelling interest, it still doesn't meet strict scrutiny. But there's a trick here, right? Because you might think, okay, right, like, so then the problem is that the universities had amorphous categories. They sort of had this amorphous idea of diversity and like, how clever it makes the classroom discussion and so on and so forth, right? So, okay, what if the universities just figured out a target? For example, what if the universities said, okay, we think that we would have achieved diversity if the proportion of people of different racial backgrounds matched the overall population, right? It sort of looked like America. Well, the catch is that the court has said you can't do that either. And this is one of what I think of as kind of a trap in the previous case law about affirmative action in colleges is you can't have a quota, the court said. Why can't you have a quota? Well, because for the court, in the court in Grutter, the court in Fisher versus Texas says if you've got a quota, if you've got like, okay, you have to have this many people from this group and this many people from that group, then you're not really treating applicants as individuals anymore. And the court thought that that was inconsistent with the goal of the 14th Amendment to try to get out of just like categorizing individuals by their race. And so there's this weird kind of double bind that's been in the doctrine for a long time, where on the one hand, because of strict scrutiny, you've got to be able to show that what you're doing in some measurable way is actually achieving the outcome of diversity. But on the other hand, if diversity is like anything quantitative and measurable, well, then it's just a quota system. And so then, you're out. And to my mind, what the court really did fundamentally in this case was it finally sprung that trap. And interestingly, right, like if you remember Fisher versus Texas, which was the last time affirmative action was before the Supreme Court, like it almost got sprung there. So Fisher versus Texas, the first time around, it got to the court, and the court said, actually, the lower courts gave the universities too much deference. No, they really have to prove that what they're doing is helping increase diversity. And then it came back again in Fisher versus Texas too, and the court said essentially, okay, fine, like I guess this is good enough. And basically the reason is that Anthony Kennedy was still on the court, and Anthony Kennedy was the deciding vote for maintaining affirmative action. But it was pretty clear from Fisher versus Texas that this trap was just waiting for a fifth vote on the more conservative side to spring it. There were a few other really interesting implications of this case. I think that one thing that we need to think about is there are a few exceptions that the court carved out. So, military academies, the court specifically said that you don't have this opinion is not going to apply to the military academies. Individuals also, the court specifically said, okay, if somebody writes in a personal statement about how they overcame racial discrimination, a college can consider that. But both of those I think are fairly minor exceptions. I have a few more things that I might want to say about them, but maybe I'll say them in a few minutes because I can already tell that I'm going on a little longer than perhaps I ought to. But there's one other really important analytical point about the decision that I think we need to remember, which is even though all of the stuff that I said about strict scrutiny and so forth is 14th Amendment doctrine, the 14th Amendment only applies to the states. The University of North Carolina is an instrumentality of the state of North Carolina, but Harvard is not. And so one important subtlety in this case, which I think is a bit of a problem, is that the court applied the 14th Amendment standard to Harvard via Title VI of the Civil Rights Act. There's something like footnote 2 says, oh, by the way, nobody disagrees with the idea that we should just apply the 14th Amendment standard here. Here's a little bit of case law that sort of casually mentions that. Memo to the court, I disagree with applying the 14th Amendment standard here. Actually, I think this is a really big mistake. Harvard made what I view as a pretty big mistake, not arguing this difference in any vigorous way, because we actually know under lots of contexts that the 14th Amendment standard and the federal statutory standard in race discrimination laws about private actors like the Fair Housing Act, Title VII, which is employment discrimination, these are different standards. I think based on the internal logic of the decision, it makes some sense, right? Like the trap that the court found in the diversity rationale for affirmative action is real, right? Like if you think that you need to be able to measure whether or not an actor that's subject to strict scrutiny is achieving the compelling interest that it's supposed to achieve, and you think that you can't have a quota in a diversity rationale, that's a deep tension, and the court found that tension. So I really think the problem is with the idea, the sort of basic premise of the case, which is that the justification for affirmative action in college admissions is educational diversity. And now, don't get me wrong, educational diversity is a good thing, right? I'm not saying that educational diversity by itself is bad. In fact, there's lots of really good social science, for example, showing that, groups of people trying to learn and make decisions do better under conditions of diversity than they do when everybody's homogenous and thinks the same way. But there are lots of better rationales for affirmative action that the court has never explored because we've all been so stuck on this diversity idea. And there are lots of problems within the diversity idea, right? Like the trap thing. The fact that you can't really measure diversity except by having a quota, that's a problem. More importantly, however, I think there's a moral problem with the diversity rationale. So, Derek Bell, for a professor at Harvard and at NYU, who's one of the founders and one of the early giants of critical race theory, is well known for what he called the theory of interest convergence, which is essentially the idea that benefits of people of color are always conditional on those benefits also serving the interests of those in power, namely whites. And the diversity rationale for affirmative action is a quintessential example of interest convergence. If you look at the original case law establishing the diversity rationale, what you see, for example, in Gowder, you see like this big emphasis on the military, this big emphasis on the idea, well, the military has come and they've filed a brief saying that we really need officers who are well trained to command diverse groups of soldiers in battle. And so that's why there should be affirmative action. And I mean, that's just like, I mean, it's deeply immoral, right? Because, we know that there are continuing actual disadvantages in this country that people of color suffer, that go back to the legacy of slavery and generations of state-sponsored racism. And so what the diversity rationale for affirmative action said is, oh, well, you have to be able to prove that you're improving the education of a bunch of white kids in order to have the excuse to have an affirmative action program, right? And so, yeah, I mean, to my mind, that's immoral. Like the morally justifiable way to defend affirmative action is either number one, as full-on reparations, right? In other words, as a remedy for present day and historical discrimination, the idea that something was taken by the state from students of color and it's time to give it back, but also in meritocratic terms, right? There's this idea that I think is true, that there's a lot of talent that gets missed. You have to jump through a lot of hoops to succeed in college admissions, right? Particularly at the highly competitive colleges that do the most affirmative action, you have to have these AP courses. Well, not every high school offers AP courses, right? You have to have high test scores. Well, not everybody has access to test prep in the same way. Like, there are all of these background conditions of inequality that are likely to leave students of color behind who are just as talented, who have like IQs just as high as somebody who's like upper middle class white person applying to Harvard. And so one justification for affirmative action is that it allows the schools to capture that, to say, okay, I'm going to understand that you might not have gotten the opportunity in high school to show that you're as talented as some of these other people. And so we're going to give you that opportunity now. Either of those things would be a much better justification for affirmative action than the diversity rationale that the court de facto, if not de jure, killed off. I think the other thing about diversity, and this is, I'm going to say something a little controversial here, which is I do think that diversity itself as a rationale for college admissions has a kind of corrupting influence. And I think this is something that the conservatives were actually right about. And they're right about it because, I mean, to be perfectly frank, right, like college admissions officials are bureaucrats administering a complicated system, and that generates a lot of perfections, sometimes outright incompetence, sometimes just imperfections built into the system. Right, so I'll give you a couple of examples, right? One is, the sort of big elephant in the room in all these cases, of course, is the risk that there might be discrimination against Asian Americans in particular. Why might there be discrimination against Asian Americans? Well, there's sort of two stories. I think one is more compelling than the other. Right, story number one is, well, colleges trying to achieve diversity might think they have too many Asian Americans because people get high test scores and so forth, and so they've got to bring them down. Right, like I don't think there's a ton of evidence for this, but it's a real danger. I think that the serious danger, however, is a lot deeper, which is that the diversity rationale encourages admissions officers to what I think of as kind of like going on a hunt for special snowflakes, right? It encourages admissions officers to be like, okay, how do I tell a story about how someone is like different and special? Oh, they play the oboe, but like they also play the oboe while hopping on one leg. Okay, right, that person's unique. Let's get them into the class. But this interacts really badly with a nasty racist stereotype about Asian Americans, right? There's this nasty stereotype of Asian Americans as grinds. And again, it's a stereotype, it's false, it's racist. But I do worry that admissions officers subscribe to that stereotype. And so they might be less likely to see Asian American students as representing the kind of special snowflakes that the diversity rationale encourages schools to chase after. The other thing, and I mean, this is just sort of a like personal bug of mine, is like, and again, it's sort of about like taking a standard that sounds good and applying it in like practice is, the number of times that I've heard people in university contexts refer to a person as diverse, like, oh, we've got a diverse candidate for this like class or whatever. I mean, it's just, okay, first of all, that's just false, right? Like a group of people is diverse, an individual is not diverse. But I mean, it's just this kind of weird and creepy, right? Like by focusing people in bureaucratic roles on this notion of diversity, it actually leads to people sort of reducing individuals to their contributions to a larger group in a way that, again, I think is morally problematic and wouldn't be the case if instead of thinking about diversity, we thought about justice and reparations or thought about merit that's hard to find. And so really, in a way, like I don't have a critique of the decision so much as a critique of the limited horizon. We really need to take a forward-looking approach to this, right? I mean, right now, the fact of the matter is that we're probably going to see schools that are a lot less inclusive going forward, particularly at the elite level, like I said, where these things matter. But I don't think we need to lose hope. And here are a few reasons why I don't think we need to lose hope. So one is not, the stuff that I said a few minutes ago about thinking about ideas like meritocratic and remedial justifications for affirmative action, those are real. So, story time, right? Like during Reconstruction, freed people and radical Republicans argued for like positive efforts to promote economic inclusion. I think that our constitutional law carves out a room for us to actually start saying, and it's going to take a while. We're going to need a few more justices that are a little bit more sensible before we get there. But I think we really have the opportunity going forward, even if it takes years, to start making the argument that actually conscious efforts to use economic inclusion to remedy racial discrimination are within the 14th Amendment, and it's something the state can actually do. In the meantime, here's what I think we can do now. Number one, Congress. Harvard, again, it's not the state. Harvard is a private university. It's regulated by federal law. It's federal law that the court applied, saying that they can't do affirmative action. Congress is in control of that. Congress could change that in a heartbeat. Second, I think more interestingly, and again, this is particularly focused on Harvard, partly because I went there for law school, and so I think about them, but also partly because people tend to focus on them. I mean, they're really prominent. There's already a complaint that's been filed within the Department of Education over legacy and donor admissions. right? And I think that's a really good complaint because if you think about it, legacy admissions, donor admissions, frankly, that's affirmative action for upper class white people, right? Prior generations of Harvard students were primarily white because of race discrimination, because it wasn't that long ago that every university except for the historically Black universities was explicitly discriminating on the basis of race and admission. And so their grandkids and their great grandkids, who are again going to be predominantly white, are going to be benefiting from that. I think that's a really easy case under Title VI for race discrimination in admissions. And so I think that moving forward, it would be interesting to see what happens with this case. But I think that you're going to see a lot of challenges to the forms of inequality like legacy admissions that our elite universities already build into the package.